Let's be honest. Your health is crucial for your future and your ability to continue working, especially in the maritime industry. Whether you're the captain or a deckhand, the job demands a lot of physical work, often in challenging and dangerous environments. If an accident occurs while you're out at sea, even a small injury needs to be treated promptly and correctly. Knowing your rights when injured on the job is important. It ensures you can receive the medical attention you need without worrying about hospital bills. We'll start with a few basic maritime rights, which you should also share with your fellow crew members. One key point to remember is that you should almost never use your own health insurance for maritime injuries. These medical expenses should be covered by your employer. Remember, you don't have to provide a recorded statement to get your medical expenses covered. Some companies might trick you into doing this, but keep in mind, what you say can be used against you. You have the right to pick your own doctor for your medical care. You're required to visit a doctor chosen by the company, but just once, and it's absolutely okay to see your own doctor first. A company-chosen doctor might not always be eager to suggest important tests like MRIs, CT scans, or nerve testing that could reveal the seriousness of your injury. If the tests they perform don't uncover what's truly wrong, the company might claim you're not injured, which could be misleading. These company doctors often communicate directly with your employer or their insurance company about your condition, possibly excluding you from your own care plan. On the other hand, a doctor you select, possibly with the help of an experienced maritime attorney, focuses solely on your health needs without being influenced by your employer's expectations. Remember, if any doctor, even a company doctor, states you no longer need medical care, the company might stop approving further treatment and expenses. When you've experienced a maritime injury, it's essential to undergo the right medical tests to ensure you're on the road to recovery. Beyond basic x-rays, you should anticipate having MRIs and nerve conduction studies. If you find that the company doctor is hesitating to conduct these basic diagnostic tests, it might be a sign they're prioritizing your employer's interests over yours. Don't hesitate to seek another doctor's opinion right away. Unfortunately, some employers may shy away from the costs of diagnostic testing. They might avoid confirming the severity of your injury, even if it means delaying the support you need. Here at the Young Firm, we've been advocating for injured maritime workers for over 30 years and have seen such situations repeatedly. You should be aware that if you go to your company doctor, medical negligence could happen. Seeing only a company doctor can severely damage your claim, and depending on your injuries, could be extremely hazardous to your health. Admiralty laws require that companies be held liable for damages if such medical negligence occurs. Remember, your employer uses their own doctor typically to limit their chances of being sued. They are a business, not your family, no matter how often they like to say that they are. If your family was in charge of your healthcare plan, they would never refuse you tests or coverage. If you're an American working overseas on an oil rig or vessel, there are a few extra things to think about, especially regarding international travel and the necessary medical care. Maritime law, including the Jones Act, ensures that your employer must promptly provide medical treatment for any injury or illness. If there's any delay in receiving this care while you're abroad, that might open the door to a legal claim, especially if your condition deteriorates. Often this situation isn't about a specific work-related injury. It can happen if you just fall ill with a disease, virus, or infection. Regardless of the cause, be it a work-related injury or a non-work-related illness, it's your employer's duty to ensure you receive proper and adequate medical treatment. Remember, if your employer chooses the doctor or hospital for treatment while you're in a foreign country, they are accountable for any medical negligence on the part of those professionals. Many offshore rigs and vessels are located in remote areas where proper medical facilities or specialists aren't readily accessible. Medications that are common in the United States may not be so easy to find there. For example, one of our clients suffered a routine stroke while working on an oil rig off the coast of South America. Unfortunately, he was taken to a small local medical facility that lacked the resources and expertise to handle stroke cases. What could have been managed as a temporary ischemic attack, TIA, turned into a major brain hemorrhage due to the absence of clot-busting medication that is standard in the United States. Thankfully, he secured a successful settlement which took care of his future needs.